okay, what is the value of all of my personal property? Because that is also going to trigger whether or not you need a trust-based plan versus a will-based plan. And here in California, if your estate, the current amount is $160,500. If you have assets above $160,500, has to go through probate to be transferred. Anything under $160,500, you can transfer an abbreviated procedure under Probate Code Section 13100. The problem becomes is, with regard to personal property, how do I transfer personal property? How do I know that it is part of the trust or not part of the trust when you do have a trust-based plan? And so when we do a trust-based plan, it's not just one document, it's a series of documents. So with regard to the personal property, one of those documents that we do is called a general assignment of personal property. Because you think about it, all of this stuff that you've accumulated, it doesn't have a certificate of title like your real estate has the deed to the house. Okay? Well, what about my dining room furniture, my living room furniture, my artwork up on the walls? How do I know that that's been put into the trust if that's what I'm doing? So we do a certificate of title, assignment of personal property is what it's called, that transfers everything into your trust. And in the trust-based plan, it says, all of my personal property, whatever it is, whatever I've accumulated over my lifetime, goes to whoever, if it's to your kids equally as they agree. But however, people acquire stuff that's sentimental or that's personal to them. For instance, this ring that I wear is from my grandfather, and he wanted to pass it down to me. And I intend to pass this down not only to my son, but to my grandson. How do I do that? Because if you just say that it's part of your personal property and it passes to your heirs as they agree, how do we know that it goes to my son or to my grandson? So what I do with my estate planning documents is I have a separate exhibit that I have my clients fill out in their own handwriting. And I use it for this kind of stuff, like the ring. It's like, what piece of property goes to who? Dad's got this gun collection, or Dad's got this coin collection. Who is it supposed to go to? And I have my clients do it in their handwriting. And I tell them, and they say, well, we'll give you the list, you type it up. And I say, no, I don't want to be the one to type it up, and here's why. And this has worked really well for me in the past. That's the stuff that people are going to argue about when the time comes. And whoever the successor trustee is who's settling the trust, when they have the book in front of them that we provide, there's the exhibit in your handwriting saying, the ring goes to my son, the coin collection goes to my daughter. They turn the book around to who's ever complaining and push it in front of them. See, it's not, I took mom to the lawyer and that's what, they told the lawyer, but not really what mom wanted. There it is in mom or dad's handwriting. So it cuts the knot real quick. It's worked like a charm for me in the past. I had one client in Rancho Santa Fe that accumulated a lot of different collectibles and artwork. And in her case, we knew one of the daughters was going to raise a holy heck when it came time. And so with her, I said, here's what we're going to do. I said, you and your other daughter who used to come in with her, I said, I want you to take digital photographs of everything that you want. I said, and we're going to attach copies of all the digital photographs with your indication on that page, who it's to go to, and you're going to sign it. And lo and behold, when the time came, absolutely not a problem. So, how you account for your personal property items is really important. And having a trust-based plan that has that kind of fluidity to it is really important. And people don't think about that because, they just think, well, my family will do what is right. Well, nobody knows what is right according to the way that you want things to work out. And I tell people, having a trust-based plan is kind of beautiful because I tell my clients, if you can dream it, I can draft it. Just tell me what you want, and I can put it into words and make it have effectiveness. Because a trust is like a contract, and like any other contract, it's got terms and conditions, and those terms and conditions have to be abided by. And as long as you specify in those terms and conditions who gets what and under what circumstances, the document, you can rest assured, will have that kind of effect when and if the time comes. So, in terms of passing on personal property, I think it's really important to give consideration to items of extraordinary value, of sentimental value, and then have a plan in place that addresses how they're going to be transferred. And I tell my clients, as I give them the estate plan, and it's in a nice binder when I give it to them, and it's got all the proper documents to transfer the personal property. But let's say, today they get this binder from me, and then next weekend they happen to go up to Laguna, and they're walking through, and they see this really cool piece of artwork, and it's like $5,000, and they buy it. Well, how is it in the trust? Is it not in the trust? And I tell my clients, okay, with something like that of extraordinary value, have the bill of sale made out to you as trustee of your trust, because that automatically puts it into your trust. Think of your trust like a box. And if I've done a good job as a lawyer, I've drafted a nice sturdy box for you, but it's empty until we start to put stuff in the box. So from this point forward, if you decide to buy a valuable painting or buy a collectible, take title to that asset in the name of the trust to you as trustee of your trust. That automatically puts it in the box. You don't need to come back and see me. You've done it. You can always call me and ask me, is this the right thing to do? And I can say, yeah, that's the right thing to do, and you don't need to come in to see me. But what happens if you're going to buy a vacation piece of property, vacation home? What do? Well, again, there's a document that we provide called a certification of trust. And the certification of trust says who the trustee is, what the name of the trust is, what the tax ID number is. And you take that certification of trust and you give it to the escrow company when you're buying your vacation home. And that tells the escrow company, here's what the vesting to the title should be for this vacation home. And they automatically put it in the box. You don't need to come to see me. The flip side is, let's say you've got the vacation home and you've come to me and I've put it in the box for you when we initially did the plan, but now, 10 years later, you want to sell that vacation home. It's real simple. You go to the escrow company and you sign off as trustee of your trust, transferring that property out. In terms of the money coming in from the sale of that asset, depends what you want to do with it. If it's to be part of the trust assets, it goes into the trust account. It's not meant to go someplace else, well then you pay it over someplace else. So it's a very fluid document for dealing with not only your real property, but even your personal property when you start to think of it in those terms. So, again, to bring this full circle, the significant amount of personal property that you have needs to be addressed in some fashion or another. And if it's not addressed in your estate plan, guess what? A probate court judge may be the one who decides what happens to it, and you don't want that. So, again, at the bottom, there'll be a link to set up a time to talk to me if you want to discuss some of these things. And if you really are adamant on doing this on your own, there's another link to a different website that we have that will let you go through a question and answer period that hopefully can give you a little bit more robust document if you want to try to prepare it on your own.